Hello everyone, I am Ankit and you are watching StudyIQ IAS English channel. Now today we are going to discuss a very important provision of the Indian Constitution, Article 142. But why are we discussing Article 142? Let me give you a very brief background. Now about 2 weeks back, Supreme Court pronounced a judgment which was a dispute essentially between the government of Tamil Nadu and the governor of Tamil Nadu. What the governor of Tamil Nadu did, or for that matter did not do, was he did not give his assent to 10 bills that were passed by the state legislature of Tamil Nadu. Now you understand, for a bill to become an act, it needs the sign of the governor, which is technical terms is called as an assent of the governor. Now what the governor of Tamil Nadu did was that he was not giving his assent for an indefinite period of time. So this matter eventually reached the apex court of our country, and in the judgment passed by the Supreme Court, it actually allowed for the assent to be given under Article 142. Right. So therefore we are going to discuss Article 142. Also what happened was that Supreme Court mandated a definite time frame within which the governor has to give an assent to the bill passed by any state legislature. So in that regard, let us try to very quickly understand the context of our today's discussion. Now, in the wake of this particular ruling by the Supreme Court of India that has set a 3-month timeline not just for governor but also for President of India to decide on any bill that has been referred to by the governor of a state for the consideration of president, particularly with respect to a bill that has been passed by state legislature. So in this regard, India's Vice President, Mr. Jagdeep Dhankhar, has said that India can't have a situation where actually judiciary directs the president. Why? Because president is a part of which organ of the government? He is a part of executive. And when executive will be given a direction by another organ of the government, this actually violates the provision of what is known as separation of power. Similarly, Vice President has also highlighted that the use of Article 142 of the Indian Constitution by the Supreme Court to pass any order which is necessary to ensure complete justice is actually a nuclear missile against the very democratic forces. Why is this a nuclear missile against democratic forces? Because what is a democratic setup in India? Legislature pass laws, executive implement the laws, and judiciary reviews the laws. But when judiciary starts to pass the law and implement the law, this actually violates the democratic forces, and this kind of an extraordinary power, according to Vice President of India, is available to Supreme Court 24/7. So in this regard, let us try to understand what is Article 142. Now, if you read the text given in this Constitution of India about Article 142, you will realize that it is a unique power which is provided to the Supreme Court of India to ensure complete justice in matter of any dispute between parties. Suppose if there is no particular law that deals with how to solve that particular dispute, and if that law does not provide any remedy, so in that case Supreme Court can pitch in. For example, there were many cases particularly related to the sexual harassment of women at workplaces. There was no law passed by the Indian Parliament. So in that case, Supreme Court realized this legal void and instead passed the guidelines which was popularly known as Vishakha guidelines. Now this Vishakha guidelines, in absence of any law to deal with matters relating to sexual harassment of women at workplaces, served as a sole way how to deal with such cases. Now after these guidelines were passed by the Supreme Court, then only the Parliament of India came up with its own law to deal with protection of women at their workplaces, right? So this essentially provides Supreme Court a way out of how to solve any dispute in case there is no law or if the law is silent on that particular matter. So suppose in very common language, if there is any dispute happening, Supreme Court is saying, why are you fighting? Come to me, I'll solve that particular problem, right? So essentially this is only that. Now the Supreme Court, in this exercise of its Article 142, it may pass any such order which is necessary to do complete justice, right? Now, what is the way or what is the reason behind such an extraordinary power that has been given to the judiciary under the Constitution? Let us try to understand the rationale behind it, right? First, when you give such an extraordinary power to the Supreme Court of India, it actually vests the Supreme Court with exercise of executive as well as legislative functions. Now, there are specific scenarios. Suppose what is the purpose or what is the job of legislature? It is to pass the laws.
Whereas what is the job of executive? It is to implement these laws. But there might be certain cases when executive is not implementing the law or legislator is not passing the law. So in that case, Supreme Court can take it upon itself to do such things necessary which traditionally belongs to executive and legislature. Now in doing so, for example, in Vishaka guidelines, Supreme Court understood there was no law to regulate sexual harassment of women at workplace. There was no law to punish those who actually harassed women at their workplaces. So this legal lacuna allowed Supreme Court to play the role of legislature so as to bring a guidelines that effectively had the same power as that of a law passed by Parliament. Similarly, Supreme Court, using its power under Article 142, it can also intervene in any matter which concerns public interest. Now, I don't know how many of you remember Article 262. Now, Article 262 essentially deals with any dispute that happens between two states in our country dealing with sharing of river waters. And according to this provision of the Constitution, Parliament of India can pass any law to deal with such disputes, and accordingly, the Indian Parliament has passed Indian State River Water Dispute Act of 1962. Now, what this act provides is that if there is two states that are fighting over sharing of a river water, they can approach central government, and according to this law, central government will consider or establish a tribunal to hear and give its decision based on this dispute. So whatever decision of sharing of river water is given by the tribunal, that is binding on all the states concerned in the dispute. And also this law also provides that any court in country, including Supreme Court, they can't intervene according to the decisions, or they can't intervene on the decisions given by the tribunal. But Supreme Court actually realized that public interests were harmed when it came to dividing of Kaveri river waters. So it indeed used its extraordinary power under Article 142 to change the judgment given by the Kaveri River Water Tribunal, right? So that is how Supreme Court goes way beyond its mean to ensure complete justice in public interest, in ensuring human rights are followed, in ensuring constitutional values are followed, and ensuring that fundamental rights are enjoyed by people living in India. Also, under Article 13, under Article 32, what you know that Supreme Court has the power of judicial review, and this is the part of basic structure of the Constitution. And the judicial review, it allows the Supreme Court of India to review any laws that has been passed by legislature. It can review even any decision that is made by the executive. So therefore, while doing so, it ensures that it is ultimately the protector of the values of the Constitution. It is the ultimate interpreter of the law of the land, and while doing so, it can actually go beyond its traditional powers into the spheres of executive and legislature to ensure that complete justice is happening. Now, the next question might appear in your mind, is this Article 142 power of the judiciary, particularly of Supreme Court, is it an infinite power? The answer is both yes and no. Yes, because actually we have seen in practice Supreme Court can do anything, but in reality, if you realize from the judgments passed by various benches of the Supreme Court, you will realize Supreme Court has imposed several limits on the use of such power. For example, there was this case known as Supreme Court Bar Association versus Union of India case back in 1960s, and in this case, Supreme Court has actually highlighted that powers given to it under Article 142 is not an extraordinary power. Rather, this is just a supplementary power in nature, that it can use this power to supplement any provisions of the law passed by Parliament or any provisions of the Constitution of India, and it can't negate those provisions, right? So it is only a supplementary and a complementary power, not a replacement power, right? Also, this kind of a power cannot be used to replace or override any statutory law, and statutory law, you understand, which is passed by the Parliament. And similarly, Supreme Court using Article 142 can't build a new edifice or a new concept of law where none has earlier existed. So it can't bring its own conception of justice. It has to follow the traditional conceptions of justice to ensure that justice is actually delivered. Similarly, article or orders which are passed under Article 142 can't contravene anyone's right to enjoy their fundamental right, and it can't even deny the right to approach courts in their cases of violation of fundamental rights. So suppose using Article 142, Supreme Court can't deny anyone their right to life under Article 21. It can't deny anyone or it can't stop anyone to approach the courts in case their any fundamental right is violated under Article 32, which provides for right to constitutional remedies. Also, this provision, it can't be used to achieve anything indirectly which Supreme Court can't achieve directly, right? So it is not a way to surpass anything. It can only be used to give justice. It is only used to ensure justice, but it can't be used to change any laws that has been passed by Parliament. It can't be used against any provision that is given in the Constitution. Also, in different cases, Supreme Court has highlighted that while doing so, Article 142 should ensure that no injustice is caused to a person who is not a party to the dispute. For example, if Karnataka and Tamil Nadu were fighting over Kaveri river waters, so while passing the judgment, this should not allow the injustice to happen to other states that are sharing the waters of Kaveri, for example, Puducherry, right? So therefore, any third party, they can't be at a disadvantage just because Supreme Court has ensured justice to two people, right? So this is the scope, or this is the limitation that the Supreme Court has imposed on itself, so that this exercise is not arbitrary, this exercise is not indefinite. Understood? Now, there are also certain criticisms of the use of Article 142, and what are the grounds based on which such criticisms are made? Let us try to quickly understand this. First is the subjectivity of the decision. Now, what you have to understand, that the Supreme Court, or the Constitution of that matter, in its text, it highlights that the word is complete justice. But you understand, right, that the word justice itself is a very subjective matter. That, for example, your conception of justice will be very different from my conception of justice. Suppose if a murder happens, so your thinking or your conception of justice will think that the person who has committed the murder should also be hanged by the court of law, right? But my conception of justice can also be different. I can say that that person has the potential to be reformed, so why hang him? Rather, give him life sentence so that he can live his life after he serves the sentences. So this, according to two people, the concept of justice is different. Similarly, Supreme Court not just has one judge, it has many judges. As much as 31 judges can be there in the Supreme Court. So what about their conceptions of justice? So if one judge is hearing a case according to 142, he can have another concept of justice, whereas other judge can have another concept. So that is why this word complete justice, it is not defined in the Indian Constitution. And when there is not a defined version of what is complete justice, so it can be subjected to individual interpretation. This can be quite subjective, and that is why you will see that the application and the use of Article 142 has been somewhat inconsistent. There has been demands of use of Article 142 while Supreme Court has rejected it, and sometimes there are no expectations of use of Article 142 and Supreme Court has indeed used that kind of power. For example, many say that the recently giving the deemed assent to the bills which are actually not signed by the governor is an misuse of the power of Article 142. That is why, because there is no particular definition in the Constitution itself, therefore you will see a lack of consistency in the application. Another problem is that it blurs the line between branches of the government. For example, it is very clear to you regards to concept of separation of power that there are three branches of government in India. That is legislature, which is responsible for making laws, executive, which is responsible for implementing the laws, and judiciary, which is responsible for reviewing the laws. But as you have seen, using Article 142, Supreme Court can do anything. It can pass any law that has actually the force of law equivalent to the law passed by Parliament. It can implement any provision that can be implemented by executive. For example, in 2015 or 16, Supreme Court imposed cess on diesel vehicles that are the capacity over and above 2000 cc, which essentially was a form of tax. So what is and who is responsible for implementing or who is responsible for passing any law which imposes tax? It is legislature. And who can implement the tax provisions? It is the executive. So when judiciary itself was imposing any kind of a tax on vehicles, that essentially meant that judiciary was doing the powers, or judiciary was doing the function which was originally meant for legislature and executive, right? So that is why these kind of use of powers, this gets blurred when Supreme Court uses its power under Article 142. Also, the use of Article 142 that judges themselves are not accountable to anyone. For example, members of legislature, you understand, you elect the members of legislature, both MLAs and MPs. So, essentially, members of legislature are accountable to people like you and I. Similarly, members of executive, they are part of legislature itself, and executive, they are accountable to whom? They are accountable to legislature. So that is why executive is accountable to legislature and legislature are accountable to people like you and I. But who are judges accountable to? That is a big question, because judges are not accountable to executive, they are not accountable to legislature. So when judges itself, they make a policy decision or they pass a law without being accountable as against other branches of the government, how can you ensure that their policies will be reviewed? How will you ensure that their policies or their decisions will be scrutinized properly? No, right? So this is the issue relating to the use of Article 142, that it is the concept of complete justice itself is not defined, so it becomes subjective when it comes to its application by the judges. While doing so, judiciary, it blurs the usual separation of power that is there in our constitution. While doing so, judges, they are not accountable to anyone. So how can use of such indefinite power without any accountability justified, right? So that is why this is a big issue. Now, this is all what is related to Article 142. What do you think about it? Please let me know in the comment section. Was Supreme Court right or was Supreme Court wrong? Does this need further limitation? Please let me know what do you think in the comment section. Also, there is this practice question, which is essentially the PYQ which appeared in prelims of 2019. Do let me know the correct answer in the comment section. And please let me know what you think about it, right? So I'll take your leave. This is all for this particular session.